Welcome to An Ounce of Prevention, the podcast. At our recent associates, we believe that an ounce of prevention is worth a pound of cure. Our daily commitment lies in informing our clients about legal risks without hindering their business objectives. As we like to say, we're in the business of building companies and helping executives sleep at night. So stay tuned. Maybe you'll learn something that'll help your business grow and thrive.
Welcome to An Ounce of Prevention, the podcast, where we believe an ounce of prevention is worth a pound of cure. In every episode, we'll dive into the steps that you can take today to protect and strengthen your business for tomorrow. I'm your host, Rachel Reese. Today, we'll be talking about the WARN Act, or the Worker Adjustment and Retraining Notification Act. But stay tuned after the episode when I'll cover the 10th Circuit's ruling in Atlantic Richfield versus NL Industries, a case where the court allowed a cleanup cost claim to proceed by classifying it as a timely contribution act claim under CERCLA. Greetings, ghouls, ghosts, and most importantly, deal makers. If you're heading to Houston this October, mark your calendars because you won't want to miss this. Join us on October 23rd for RRNA's inaugural Dealmakers Haunted Hall Halloween Gala, where the A&D community comes together for a night of networking and meaningful impact. Now, if you are looking at the calendar, you already know that this week is packed with high-caliber events. There's the SPE Annual Technical Conference from October 20th through the 22nd, the Minerals and Non-Op Assembly on October 21st, the North American Capital Assembly on October 22nd and 23rd, and of course, the Women's A&D Luncheon on the 23rd. So why not cap off the week in style with our event the night of the 23rd? Get ready for all the fun activities. We have poker, karaoke, multiple bars, and don't miss the show-stopping costume contest. Come dressed to win. Tickets are on sale now, and if you won't want to miss this eerie evening of industry magic. Individual tickets are just $200, so grab yours early and save your spot in the haunted hall. Bringing your deal-making team? Go for the squad ticket. Just $1,000 for 6 tickets, perfect for teams, friend groups, and partners in crime. Visit www.rreeselaw.com to secure your tickets before they vanish into the night. There are also still sponsorships available. Interested in sponsoring this year's event? We'd love to have you on board. Visit our website for details or reach out directly to explore how you can be part of the magic. This is an especially timely discussion because Chevron just issued a WARN Act notice in April of this year for its workers in California and Texas. The WARN Act was enacted in 1988. This law requires that employers give 60 days advance written notice before they close a plant, a site, or before they do a massive layoff. Generally, the WARN Act applies to employers with 100 or more employees that are laying off 50 or more employees. Notice I said here, employees, not contractors. They have to be at a single site and it has to be done during a 30-day period. If an employer does not provide the notice, they are subject to having to pay back pay and benefits to affected workers, and there are per-day penalties that they have to pay to the government. There are some exceptions to this general rule that you should be aware of. The biggest one in my mind is this. The government will actually take a look at the terminations that happen over a 90-day period, and if they add up to more than 50 terminations, and you can't prove that these layoffs were separate and distinct occurrences, then they may determine that this was an attempt to evade the WARN Act, and you may be subject to WARN Act penalties. Now, it seems like the WARN Act would only apply to the largest oil companies, because most oil companies aren't employing that many people, or they're using mostly contractors. But the reason I'm discussing it today is when you're buying a large asset from one of the majors, or a company is selling you its entire position or the company itself, you may be tempted to take all of the employees involved with the asset, thinking that you can later decide whether you truly need them or not. But this may subject you to the WARN Act if you eventually decide to do a layoff. In these larger transactions, we also see compliance with the WARN Act pop up under the reps and warranties section. So this is another reason that you need to know what this is. You also need to ensure that the company that you are buying from is obligated to comply with the WARN Act, so that none of the potential penalties involved with the WARN Act could end up on you. With all the consolidation that's happened in oil and gas over the last few years, we're all hoping for what has been dubbed the Great Divestiture, where the majors will start selling off some of the non-core assets they picked up in these consolidations. When that happens, you're definitely going to see WARN Act issues popping up more and more. So think about this before closing your next transaction and seek the advice of legal counsel to guide you through the process. Okay, that's all for today. I hope you learned something. If you have any questions about the WARN Act and how it affects your company, give us a call. And now it's time for another case law update. Today's case is a recent ruling from the 10th Circuit Court of Appeals called Atlantic Richfield Company versus NL Industries. This case revolves around an environmental contamination from an old mining site in Colorado that leaked sulfuric acid into a nearby river. The EPA stepped in back in the year 2000 to try to stabilize the situation, but the leaks persisted. Fast forward to 2011, and the EPA ordered Atlantic Richfield to build water treatment systems. Then, in 2021, Atlantic Richfield settled with the EPA, protecting the company from future liability in actions brought by the EPA or a third party in exchange for $400,000, and continued cleanup work. The following year, Atlantic Richfield sued NL Industries, a Texas-based lead smelting company, who was involved at the site, for contribution towards these years-long environmental cleanup costs. The U.S. District Court for the District of Colorado granted partial summary judgment in favor of NL Industries, finding that Atlantic Richfield's claims were time-barred by the limitations period for a cost recovery action outlined by CERCLA. However, on appeal, the 10th Circuit unanimously reversed this ruling. The core issue in the appeal was whether Atlantic Richfield's claim was one for contribution or cost recovery. This distinction is essential, as these two claims have different statutes of limitation under CERCLA, making this a make-or-break question for Atlantic Richfield's case. In reversing the lower court's ruling, the 10th Circuit ruled that Atlantic Richfield's claim was more appropriately characterized as an action for contribution rather than cost recovery. The ruling emphasized that even though the statutory provision listing contribution claims did not specifically include this type of settlement, the nature of the action in previous case law suggested that the 3-year limitations period for contribution actions was the closest fit, meaning Atlantic Richfield's claims could proceed. Under CERCLA, an action for a contribution refers to an effort to require a partially responsible party to pay their proportionate share of costs after an administratively or judicially approved settlement that resolves a party's liability to the federal government for an environmental response action. Here, once Atlantic Richfield settled with the EPA back in 2021, the statute allowed it to seek contribution for its expenses from those parties that had not joined in the settlement. Because the contribution statute of limitations applied, Atlantic Richfield had 3 years from the settlement date to file suit against any non-parties, which it did. In sum, Atlantic Richfield's claims were timely and valid, and they were entitled to try to recoup contribution costs from NL Industries. So why should you care? EPA actions and CERCLA cases are messy. There are a lot of moving parts, and everyone is pointing fingers at everyone else. But statutes of limitation provide a complete defense to some of these claims. So if your company finds itself involved in one of these matters, it's on you to make sure that you identify all responsible third parties and bring them in at the appropriate time so that your company isn't left holding the bag. That's all for today. I hope you found this helpful. I'd like to thank Miguel Otoro from our DFW office for his help on this update.
The information and material in this episode is general information about our practice and firm and is for educational and informational purposes only. This information does not offer specific legal advice, and the use of this information does not create an attorney-client relationship with RRNA or any of its attorneys. The information in this episode, or any episode of An Ounce of Prevention, should not be considered legal advice, and persons should not act upon this information without first engaging professional legal counsel.
Thank you for listening to An Ounce of Prevention, presented by R. Reese & Associates. If you found this episode informative, subscribe to, rate, and review our podcast on Spotify, Apple Podcasts, YouTube, or wherever you listen to stay up to date with future episodes, case law updates, and breaking news. If you have any questions or are interested in learning what RRNA's outsourced legal department can do for your company, reach out to us at podcast@rreeselaw.com. That's podcast@rreeselaw.com. Follow us on LinkedIn or call 832-831-2289.